Good evening, everybody. This is Allison Williams here of the Williams Law Group. You are watching Moving Families Forward with Williams Law Group. So, for those of you that don't know about the show, thank you for watching. Thank you for tuning in. This show is really a conception of me and certain members of my firm where we really wanted to help bring to our local community and people throughout the state of New Jersey information about families, family law, and the issues that overlap with the people that we serve. So we have any number of clients that go through divorce and child custody matters, and it's often a very, very difficult time. And one of the things that we have seen a lot is that the clients that come through it the strongest, that have the best life after divorce, are the people that really approach their divorce as an opportunity to start over. And not start their entire life over, but start over that part of their life where they actually get to define for themselves what they want to accomplish, where they want to live, who they want to associate with. A lot of those compromises that you tend to make in marriage that are just not necessary anymore because you're not going to be a married person anymore. And so we have had any number of our clients that have really made transformations in life, and really through the help of some of the great people that help our clients, the leaders, the thought leaders, the innovators, the service providers, even some product developers that really give value to our community of clients. So with that, we decided to create this show so that we could introduce you to the wide array of providers that give a lot of value to our clients. And with that, we have this show interviewing our guests about what it is that they do that can help our clients. So tonight's guest is particularly special to me. I have actually had on this show quite a few number of talented people and actually quite a few friends of mine who've become friends through the work that they do with my clients. But tonight I have someone that isn't just special to me as a friend. She's special because of the work that she does and because of the topic that she's talking about tonight, which is special needs children. So I am very pleased to welcome to the show my friend and a true expert in her field, Christine Matus. Christine, welcome.
Thank you so much, Allison. I'm so happy to be on the show. Really excited to share whatever I can to help everyone. Thank you.
You're very welcome. So let me now tell everybody a little bit more about you, because of course I glossed over that because I was starting to well up a little bit talking about this topic. But Christine is the mother of a special needs daughter, and she has used her own personal circumstances to really fuel the work that she does for her community as well as in her law firm, which is located in Toms River, New Jersey. So, with that, I want to now turn to give you a more formal introduction of Christine, and then we're going to hop into our topic for tonight. Our topic being unique solutions for unique families. So, Christine was admitted to the bar in the state of New Jersey and the U.S. District Court of New Jersey in 1995. She is a graduate of Douglas College, Rutgers University, with a Bachelor's of Arts in Economics from 92. And in 95, she graduated from the Touro College with a degree, her Juris Doctor. She was very decorated in law school and actually was senior staff on the International Law Review, as well as receiving the Outstanding Service Award and the highest academic award in civil rights for the Civil Rights Law Clinic. Christine is a member of the State Bar of New Jersey, as well as the Ocean County Bar Association. And she's also a member of APALSA, which is the Asian Pacific American Lawyers Association and the American Bar Association. She speaks very frequently to the local community as well as to the bar on these various topics. And she is quite established in her community as well as being somebody who's a firm believer in giving back. And so, in that regard, she's a volunteer for Caregivers Inc. She is a Eucharistic minister, a board member of the Ocean County YMCA, and a member of the Central Jersey County Rotary. So, with that, we have quite an established attorney as well as somebody who just has a genuinely good heart and does wonderful work for the people that she serves. So, Christine, again, welcome very much. Welcome to the show.
Oh, thanks, Allison. That was a great introduction. Thank you so much.
So, as I said before, we're going to be diving into the topic of unique families, unique solutions for unique families. And so, one of the things that I wanted to know early on, and I think this is something that you and I talked about for a brief period of time, but if you could share with our audience, what made you want to go into this area of law?
Oh, thanks, Allison. So, I come from a family that we're always serving, we're always helping. My father's retired physician, my mom's retired nurse, my aunt's a nurse. We're always trying to see what we could do to help. And so I think growing up in that atmosphere of always serving and helping has had a profound effect on myself. So I've always gravitated towards the law. I remember as early as 12 years old hearing for the first time lawyer and what they do. But it wasn't until I started my family with my husband that we really started to narrow down what we really wanted to do and how we could help people. Um, and you had said it in the beginning. I have two beautiful kids, Emma, who's 10, and Juliana, who's 8. And, they are the ones that drive me to do what I want to do and how I want to help people. When Juliana was born with Down syndrome, we really didn't have so much information or preparation about her condition. And so we all learned together. And she's taught us as much as we've been teaching her. We work together. With Juliana, one of the things that I've learned is that you never underestimate her or anyone. And with my oldest daughter, she's learned early on about tolerance, patience, compassion. And everyone in my family, we've all learned about unconditional love. And I can't tell you all the lessons that I've learned, but I try to give that snippet of myself to each of my clients. Every time I meet someone, I try to see how it is from their point of view and what I know I've learned and what I could do to give them hope, to give them direction, and to be a leader for them. I had heard over the weekend when we help people, they may be asking us for information and guidance, but really the big thing is they're looking for leadership from us, leadership to guide them through the maze of life. And I just feel that strong mission. That's really what I do.
Wow. So that's very profound, this idea of being a leader for your clients. And, I would imagine that, given what your personal circumstances are, what your experiences have been, that you kind of had to lead yourself when you first got the diagnosis and had to kind of conceptualize how you were going to be the parent of this very special child. I can only imagine what that was like. Did you have anybody that was a leader for you as you were going through that?
What was it was really learning through my family, learning through other community leaders, and really just reaching out of other families, sharing what we were going through, and really being so surprised of how many other families had something similar, how many other families were touched by this, how many other families just had an experience, and every little bit of advice went miles, went so long, and it helped us realize and gave us perspective of why we were here, who we're helping, and really broke down a lot of misconceptions, Allison, about what we thought we knew about people with disabilities and what we thought we understood and how we felt about it. I can't tell you the growth that we've all had since Juliana was born because, again, we really tapped into a lot of our own beliefs. We were challenged, because I'll be honest with you, it was a new situation, a new experience for all of us. And to really dig deep to find out, really those hard questions of why, what, where, how. There was a lot of soul searching. But what I loved is that we all came together and we're still learning together. I wish I could tell you every day is rosy and every day is perfect and just fun and we're flying through the air. But life is life, and no matter what our situation, you don't have to have a child or a loved one with disability. We go through things, we look for the opportunity in everything, and we learn there's lessons in every single situation. There really is.
Definitely. Well, Christine, I wanted to let you know that your husband and in-laws are here.
Oh, that's
Stephen
great. Always good.
So
Yes,
thank you
that's
for
right.
tuning in. And by all means, please feel free to contribute to the conversation as we have our expert on tonight, Christine Matus. So, Christine, you said that you had a lot of misconceptions about what
Yes.
it would be to be the parent of a special needs child, but I'm sure that you also probably wondered what was available to help you, because I mean I can only imagine how overwhelming it was to get that information, that news, and then you had to kind of deal with it. So, what
Yes.
tools do you know of that you help your clients with when it's time to actually protect a child or an adult that are diagnosed with special needs? How do you do that?
Well, one of the great things about where we living in this time is that there's so many options, Allison. uh, every other year, even just as 2 years ago, more options have opened up for our family members and people that we know with disabilities. Legally, there's several options, and there's some popular ones that probably everybody's heard of. There's things called power of attorneys. There's things called guardianships, conservatorships, and then there's things called trusts. These are types of tools that we have in our toolbox that we like to use, but it doesn't fit for everyone. Everyone has a different issue. Everyone has a different situation. So it's not fair to open up the toolbox, spill it on the table, and say, let's just use them all, because they may not all be necessary. Maybe some of them are necessary and maybe none of them aren't. So, the good thing is that we do have an array of options, which is great. And I started out with some of the most basic ones, like a power of attorney, and it builds up to more complicated tools, but it depends again on the issue and the type of solutions we have. But it's exciting because there's more and more new things that are happening, Alison, that are really bringing people to the table to talk about these issues. It used to be taboo. I mean, I have clients today that will tell me that when their child was born, specifically the doctor or a professional would say to them, it's best to just leave the child here. Let's pretend this never happened, start over again, and we'll take care of the child. I mean, that was an actual advice from a professional. And
Wow.
and it's not that long ago that was happening. And I remember a client telling me that in her gut she was saying, no, this is my flesh and blood, but yet she was torn, because here's someone who she felt was so educated, more
Mhm.
educated than she felt in herself, and she just couldn't bring herself to do it, and she fought it. But not everyone does. It doesn't mean they were less educated. It's just that it was based on the times. And when you think about where that advice is versus now, we have movies, plays, music, where that's not someone to be shunned, ignored, or put away. I mean, we see it on. I love it in Target advertising, and even in the Gerber baby, is now a child with Down syndrome. And
Mhm.
my one of my missions, though, Allison, is that eventually we don't even have to have that qualifier, right? Here's a child, end the story, baby, love them, that's it. Instead of here's a child and they have Down syndrome, here's a child and they have autism. We don't, I would love it if we don't have it. It's just a characteristic. We don't say, hey, here's a child with blonde hair, hey, here's a child with orange hair. It's just a child. And we're getting there. We are getting there. I know that. But like I said, that's one of my missions, is that we just shake off all of those generalities, those little peculiar little qualifiers that we need to say. But yes, more and more tools are available, and it's exciting. And I love discussing that with my families. But, our main thing, Allison, is that we need to find out what their goals are. What wakes them up at night? What keeps them up at night? What worries them and gives them that pit in their stomach? And probably most of them are the things that my husband and I often talk about and we think about, and we take a deep breath and we say, let's look in the toolbox, and this is what these tools are for. So it's a good thing. So, those are things to keep in mind, that there are things that can be done. And it's just exciting for us to talk about. But there's more and more things, Allison. So it's good stuff. Very good.
Yeah, yeah, definitely good stuff. I just want to note that Emma is watching and says hi.
Oh,
So
great. That's
yeah, one of
great.
the great things about being a parent is that you always have eyes and ears on you, even when you're not in the home. Uh,
That's right.
so
I
so one of
love
the
it.
beautiful
Yes.
faces that we hear a lot about from Christine is Emma, and I'm glad that Emma is able to watch and join her family with that. Christine, you mentioned some of those tools, and I know this is not really a lesson on all of the tools, but I've heard a lot about guardianship more and more as time goes on, because a lot of people who have a special needs child that grows into being a special needs young adult. And then you're approaching that time toward emancipation, which is something that we deal with in a family law firm. We oftentimes have the question of, should I seek custody or should I seek guardianship? But one thing I haven't heard a lot of questions about is conservatorship. So, can you tell us a little bit about guardianship versus conservatorship as a tool for someone who might have a loved one who has special needs.
Absolutely. So, conservatorships, again, is another tool that we have in our toolbox. Not as popular, Allison, as a guardianship. So, I'll give you a scenario. So, we had a client that had come to us a few years ago, and he was one of four children. Mom had passed away, and in her will, she had decided that she just wanted to leave her estate to two of her boys, and they're all adult men. These two adult men, unfortunately, weren't fully capable of managing finances. However, they could drive, they were working, they had some part time jobs. We would see them regularly in other outings. But when it came to finances, that's where the challenge was. So, Big Brother, who called us, was a little concerned, saying that, Christine, if we were to follow through with mom's wishes, these funds would be dissipated, would be spent in nothing flat. And what can we do? So we really had to think about what are the options. When you have a guardianship, that means the court is appointing someone, and you can make this application on behalf of a loved one. But this person now is responsible for them, not only for their finances, but for their health and in their entire welfare. And that it may be appropriate in some cases. In the case of these gentlemen, they, like I said, were capable. They were able to manage and take care of themselves. But it just seemed that when it came to the area of finances, of money, of a budget, that was overwhelmed. So we decided, through his brother, that the best kind of tool for that family was the conservatorship, where he was an agent for his brother. He was appointed for his two brothers to just manage the finances, to manage the funds, but everything else they were in charge of. They can go to the doctors on their own, and they could still manage and go to work and do whatever they'd like to do. They could vote, they could do things. But when it came to finances, Big Brother was still involved. Big Brother would help them do a budget, make sure the rent was paid, make sure other things, other bills need to be up to date, and that they actually should be setting aside a savings account for that rainy day. So that's where it's appropriate. The reason why it may not be as popular as the other tools is probably also because of tools and usage and the capability of the person. Oftentimes, many people who may not be able to manage their finances also can't manage other major things in their life. So the guardianship seems to take over. That's from my personal experience, what I've seen with the clients that we've come through. But yeah, conservatorship has been a tool that we've used. I wouldn't say often, but when the circumstances fit, it is a very good, comfortable tool. And in anything, you need to be involved with people who are trustworthy, people who are familiar with each other. And it helps when, in this situation, the brothers recognize that. They said, "Yeah, we're not confident in ourselves either when it comes to finances," and it worked. It really did. But those are things that we need to be alert, and that, again, one of the reasons why when we speak to clients, we really want to know the whole picture, what they can do, what they may not be able to do. I have to tell you, Allison, saying the word "can't" is hard for me. Emma will tell you, my daughters will tell you, we don't. There's certain words we don't say in our house. We don't say "can't." We don't say "give up." We don't say "forget it." We really try to see a way around it. And it's funny because there are times where I forget to clue in other family members, and Emma was like, "Oh my gosh, so and
You
so
said
said
the
the
C
C word,"
word,
and I'm like,
right?
"What's that?" I'm like, "What's that?" And I'm like, "Can't word," and we don't say that. Or the can't give up. We can't even say it in the game. We have to see the game through. We can't, or a puzzle or a riddle. She'll give us a riddle, and I feel like saying, like, I'm like, I can't figure the answer out, Emma. So anyway, when we talk with our clients, we really try not to talk in terms of what they can't do. What can they do? What's possible? And what can we do to get around the other issues that we have to make everything possible? So that's a conservatorship.
Well, thank you for sharing that. And I want to thank everyone who is here. For those of you that are here and watching, thank you for being here. You are watching Moving Families Forward with Williams Law Group. I am Allison Williams, the owner and founder of Williams Law Group, and we are talking to our special guest, special needs attorney, Christine Matus. And Christine, I want to just ask everyone that if you are getting value out of this live, please do share the live. Let other people who are out there who need to have the valuable information that Christine is sharing with us to have access to that. So please share the live. And if you have any questions, please do feel free to engage. Throw those out there because Christine's going to be with us for the hour. And speaking of which, we actually we do have a question from our guest Steffi Di Bartolo. So her question is, what age should you start guardianship when joint custody is involved?
Great question, Stephanie. Guardianship again is another tool that we can use when we have an individual who may not be able to take care of themselves, not only financially, but in other situations, right? So typically, what we feel is that if you can start the process before the age of majority, the sweet spot we've found in our firm is around 17 and a half. If we can hit that around that age before they turn majority, a lot of the paperwork that is involved is much more agreeable to all the parties. It helps because of the information that we need to put through. If they are over that age, it does make it more complicated, but there's a lot more that we need to make sure that's included in all the papers. But if you had a choice, if you can do it around 17 and a half, that would be perfect. And typically, and just to let you know, every county is particular with regards to guardianship. There's local rules. So when we're filing a guardianship in Monmouth County, there's certain things that they like to see versus Ocean County, for example. So, those are the counties that we're very familiar with. If you're doing a guardianship in other counties, we've always welcomed those inquiries. And if we are very familiar with that county, we're happy to help. If not, we're also happy to make sure you're placed in the right hands for that local attorney or who's familiar with those local rules. But what we've seen again, that sweet spot, 17 and a half would be great. And like I said, our experience is that if you can file it before they're 18, the court date might be after they're 18, which is fine. But as long as it was filed before they were 18, you're going to be in great shape. But
Great.
good question, Debbie. Thank you.
Yes, yes. Thank you very much, Steffi, for that. I want to just acknowledge Edward White. Thank you for stopping by to watch the live. And Christine, since we're talking about these tools, you were nice enough to differentiate for us conservatorship versus guardianship, and you just talked about how guardianship, tends to be a smoother process if you start it before the age of majority. But one of the tools I hear a lot about is power of attorney. So if you could talk to us a little bit about what that is, what's entailed in a power of attorney, and when someone might want to seek one, that would be great.
Great question too, Allison, because those are the little wrinkles that when we understand, great. When we don't understand, a little bit of knowledge can go haywire for a lot of people. So just in general, a power of attorney, again, it's a tool. And it's a tool where it can be used to appoint someone else to act on your behalf, to do things as if you could do them legally. So we have many uses for a power of attorney. So when we're planning and helping a family and we bring up the topic of a power of attorney, we definitely want to make sure they understand that one, it is a very powerful tool because you're appointing someone to act on your behalf, to be in your shoes. They can sign legal papers, they can appear in court on your behalf, they can make phone calls to many institutions, financial institutions, as if they were you. So that's a big deal. But to use this tool, when you want to appoint someone to do this for you, you have to be you have to have the capacity to do it. You have to be lucid. You have to have the knowledge and the capability to understand what this tool is to begin with, right? So, again, this type of tool can be used in several ways. One is yes, if God forbid one day we wake up and we're unable to make our own decisions, we're unable to speak or to verbalize what we want. We use a power of attorney because that person can step in on our behalf and help us. We've also seen power of attorneys to be used when someone is just simply unavailable. Allison, in our office, we do some other paperwork like real estate. And there are times when people need to come in and sign something and they're stuck at work or they're stuck for some reason. And they'll say, well, I'd love so and so to come in and sign for me. And if you have a power of attorney, sure, that's possible. And they're not ill, they're not incapacitated, but they're just not available. So that's a power of attorney. But when we're dealing with individuals who are disabled, or have a category of special needs, a power of attorney can still be useful so long as, Allison, It was created when that person was lucid, that person had capacity, they understood what this document is for. Because if they can't understand what the limitations or what the power is with this type of document, it's not going to be valid. It's not going to be legal, and it's going to cause a lot more problems. The upside, that person can appoint who they want to help them. So they said, I would like my mom, I would like my brother, I would like whoever you'd like. And you're doing that voluntarily. You're doing that with a clear mind and without any coercion. Great. But if we have any doubt with that, if we have someone who has limited understanding of what it is, it could be challenged. And that's a problem. The other thing is, though, Allison, what we've also found is that if we have a person who has a little window of clarity and they do it, but yet that window is getting smaller and smaller, and they may not have understood at that time what they were doing, again, it could be challenged. It could cause a lot more problems. So, again, case by case situation we have to take a look at. But one of the main issues is that when you're doing a power of attorney, we need to have that person that has capacity. But you are appointing that person to do a lot for you. You can go to the bank, you can answer questions for you. So it is a good thing. You don't need court intervention for this document. You don't need court approval for this document or appoint various other attorneys to help you with it. So it is a big plus if it's possible, if it works, if all the ingredients fall into place. We're a big believer in that, and that really will help. But we also want to take in consideration, Allison, one of the big things is if this person needs it, and if they have the capability to take it back, will that be detrimental? We've had families that say, you know what, Chris, I'd rather go the guardianship route. Why don't we see if we can do a power of attorney? And we try to really find out, why did we even want these types of tools to begin with? If we're afraid they're going to be taken advantage of, if we're afraid that they're not going to listen to us, then what's going to stop them from withdrawing a power of attorney? Because a power of attorney can be withdrawn anytime, Allison. They can tear it up. They can contact an institution and say, you know what, don't recognize so and so. I don't want them to deal with my stuff anymore. And if that's true, great, right? Because if there's a falling out, you want them to have that capability. But what if a person isn't aware of what's right or wrong for them? They may seem lucid and capable to know, yeah, I want to deal with my finances on my own, but maybe aren't strong enough. And they're really resentful of someone helping them, but we know it may be for their own good. That's the challenge, Allison. Whereas that's why the guardianships are very useful, because whether or not that person thinks it's good for themselves, but in the big picture, looking at all the facts and circumstances of that person, we don't want them to withdraw it. We do for their own good. We may not want them to have that ease to say, I don't want this anymore, take them out. And again, case by case. So we really have to determine that with families. And we have those kind of cases quite often, Allison, where we do put on the table the two tools. And I really have to, with the family, evaluate, here's the plus of this tool, here's the minus of this tool. What can we live with? What's the best situation? And I'd love to know the real formula, but there really isn't. What works for one family may not work for another. So, a lot of our sessions that we speak with our clients, they do take time, because we really want to make sure we understand how the family works, what's the dynamics of the family. So it's not a surprise that a lot of times we're really digging deep, and we need probably a few more sessions just to make sure this is right for everyone. And I like to sleep at night, so I want to make sure it makes sense to me. So that's what I do.
Yeah, well, that's definitely a great information, Christine. I want to thank you for that. In fact, as soon as you started talking about the fact that someone can revoke a power of attorney, I was thinking, God, if we could only get the right people to revoke at the right time. Because,
Yes,
my
yes.
office recently wrapped up a divorce trial where the power of attorney was the sister of the defendant. And, the defendant was perfectly reasonable, but said, I don't want to deal with this, and delegated all of his authority to the power of attorney. And the power of attorney was just difficult and drove up expenses. And at the end of the day, the court did not hold that against the defendant, because the defendant had every legal right to appoint a power of attorney. So it is definitely a very, very strong tool to be used in the right circumstances, and definitely with the help of the right attorney. So, for those of you that are just tuning in, you are watching Moving Families Forward with Williams Law Group. I'm Allison Williams, the owner and founder of Williams Law Group. And we have my special friend and guest tonight, Christine Matus, who is a special needs attorney who owns her own firm, the Matus Law Group. down in Ocean County. Christine is a very well known, well respected member of the bar who handles these issues and, in particular, helps families dealing with children or adults with special needs. So now, Christine, I want to shift a little bit and kind of talk about the financial side of things. So we know that when children get to the age of majority, if they're not going to school, they've graduated from high school, they're not going to college or vocational school, they become emancipated. And emancipation is something that most adults, most parents look forward to. I get to finally cut the cord. My parents didn't cut the cord till I was almost 30 and out of law school and buying my first car, but that's a whole other topic. Uh, but most parents look forward to the time that, all right, little Timmy or little Susie is off on his or her own, and they've got their first apartment and they're buying their own car, and I'm off the hook. And we often know that parents of children with special needs have that as a lost dream, if you will, because the child is not going to emancipate. They're going to require financial support for the rest of their life. So one of the things I wanted to ask you about is what happens when you have a child who may have a disability and that child is receiving child support, but you also want to apply for some of the government benefits that might be available, like Medicaid or SSI. What happens in those scenarios? How do you balance the two obligations that may, my understanding is child support may conflict with receiving SSI and Medicaid?
Great question, Allison. And that's actually a popular issue that happens when parents are involved in some type of family dissolution, involved with divorce or separation or any of those issues. The question does come up where we say they are thinking that the child is entitled to child support, but yet the child is also entitled to governmental benefits such as Medicaid and SSI. So, to back up, one of the things we have to realize is that child support is an asset of the child, right? I did some family law in my early years, Allison. Not enough to say that I'm an expert like you, but uh, what I always remembered is that child support is the right of the child. So that is their asset, what they receive. And that will conflict then with certain things that we need to make sure we're prepared for or to help with our child with a disability because at a certain age, they are eligible for benefits such as SSI or Medicaid. Those benefits do have a requirement. They're means tested, which means that a person cannot have assets over $2,000. If they have assets of $2,000 or more per month, they will not qualify for these valuable benefits. And what do these benefits do? Well, one of them is that it pays for all of takes care of their health situation, pays for medical expenses. SSI is supplemental monthly income that comes to them. And again, it varies. It's around 850 a month or so, Allison. And that's helpful. It's things that they should be receiving to help them get along. But when we have a child who is with parents who are divorced and they are to be receiving child support, um, without any planning, Allison, without any taking out any tools in our toolbox, unfortunately, that child support could disqualify a child from receiving those all valuable governmental benefits. So, what do we do? So, there are things that can be done. And one of the things is to build what they call a trust, right? And these are things that are unique to the community where a trust can be created so that we could have the funds for the child support placed in this trust. What's a trust? It's a box, right? And this box can be filled with, say, child support. So then it now will not be a countable asset when the parent's child needs to apply for these governmental benefits. So it's not something that'll be counted against them towards what are their assets? Does it amount to 2000 or more? It will not be if we can place the funds in that trust. You will have to decide who's going to be managing the trust. Typically, it's both parents, or one is the primary, one is the secondary. Typically, it's the custodial parent who will be in charge of the funds to make sure that money is being used appropriately. There's rules as to how that money should be used. And again, with other firms that probably do this, but for us in particular, we really want to make sure we explain to our clients what the funds can be used for, what it can't be used for, so they don't run into problems. But that's one of the big things, Allison, It's called a first party trust because it's the child's money. So it's first party, meaning it's really theirs. They're entitled to this money, but we don't want it to affect them when they're moving forward for benefits. So it's a special needs trust. And that's something to remember. There's other kinds of trust, but for this in particular, it's very useful. There are times when we've come across helping other family lawyers, and they'll let us know that, well, Chris, this is how much the child would be receiving, and it still doesn't look like it's going to hit the 2000. But remember, we need to take the big picture. What are other assets in the child's name? What are other assets that you think the child should be deserving to have? Because if we only focus on that child support alone, it may not hit 2000 or more, it might or may not. But we can't disqualify other issues or other assets that are coming to the child. So we need to take that in consideration. So we have a little checklist that we help not only just clients who are going through it, but also the family lawyers who may be dealing with these issues. We're always happy to talk with our family lawyers, people in your area, because you have so many nuances. You have a lot of moving parts, Allison, when you're dealing with your family lawyer. And that's one of the things that we like to take off your plate. Let us help your clients if they have a disabled child. Let us help them discern or at least figure out that little aspect that's going to not only help their child today, but for the rest of their life. That this is a really something that we're passionate about, that we've seen problems. And if I could just tell you a couple of stories, though, Allison, we had a couple of clients that we're so happy to help, and we always ask them if they were in a divorce. Did you have a trust made at the time? If they didn't, these are the reasons why you may want to look into it. If they did, we love to review those because we want to make sure they're up to date. We want to make sure it makes sense. But I have to tell you, a lot of times I'm not sure what was done at the time of the divorce. There were probably many circumstances that were surrounding the creation of the trust at the time, but oftentimes the trusts aren't adequate. They're not enough. There's missing vital language that could really ruin the whole purpose of why they did the trust. And it's happened just quite recently where we're able to help a client and realize that, God forbid, if she had died and the papers that she had in place, they were not effective. They really would have just been a big problem for her children moving forward. So we're always happy to at least take a look at it. And then we're even more thrilled, though, Allison, when we know it's working, when we see like, you got it, this makes sense, great. Because again, I guess just personally, I put myself in their shoes. I want to sleep at night. I want to make sure it works for them. I would never want to turn away a client and just say like, you know what? Looks 50-50, good enough. It's got to work 100%. It's there's too much involved. But
Yeah.
yeah, so those are one of the bigger tools that we could use to help children who are receiving child support and making sure they're qualified for their benefits.
So thank you very much, Christine, for that detailed explanation, because I know that child support and SSI often come up as a problem. We have another question from Stephanie from Steffi, and I'm going to ask that in just a moment. But there's one thing that I wanted to just comment upon that you noted, which is this idea of you don't really know what's going to happen in the future. So planning around the child support today is not your best option. We have had any number of cases where we get pushback from attorneys that want to just have a standard life insurance provision that says, in the event of husband's death, there's a policy in the base amount of a couple $100,000 payable to the wife on behalf of the child. And they want to have this very clear cut language. And we always push back on that and say, we want to have the language that the life insurance is payable into a trust for that very reason, that if God forbid the parent predeceases the child, and that child is a minor, and in our circumstance, more often than not, we're talking about college, then that money becomes an asset of the child. And thus, anytime that the child will be applying for scholarships, loans, grants, etc., you're going to have a problem, because the people that are reviewing that are going to see that the child has an asset that is, puts them out of the income eligibility for it. And it really is the same sort of thing with the special needs trust, or rather the HIMSS trust, rather, for a child. That if you are calculating it based on child support today, that support may be increased. It may be cost of living adjustments. It may be modified upward. And there could be other assets of the child that could really create a problem. So,
Such an
um,
excellent point. Excellent point, Allison, because that's another thing that I was trying to allude to is that, when we're trying to calculate what does a child receive when we're looking at the child support, you also have to look at the life insurance, right? Because that also becomes an asset, and you do not want the benefit. And if we're dealing with a child with a disability and we think that in the future we would like them to be eligible for these means tested benefits, life insurance could throw them off if the beneficiary is the child's name alone, right? We don't want that. We want the name of the trust to be the beneficiary. And
Mm.
again, that'll protect the child. So, but I never even thought about that other aspect about them, even if it's a typical child applying for colleges. Fantastic. Again, another reason to have that. And I think that's without that, it's you're dealing with a myopic view, a very short-sighted view of what this is used for instead of the big picture of the what ifs, because that's our job. You've been through it more often than anyone down the line. How many years experience that we've had under a belt. I've always said to my clients, I'm just here to tell you what I've seen down the road. I've been this road before, but really the option is theirs. But I want to make sure we're making thoughtful decisions. I want to make sure we've taken consideration all of the options, all of the roadblocks, all of the interesting signs that we're coming across, so that you can make an educated decision. But I learned something new from you. I like that. Very good. Very,
Yeah,
very good. Something for me
definitely.
to look
So I just want to, for those of you that are just tuning in, I want to remind you that you're watching Moving Families Forward with Williams Law Group. I am Allison Williams, the founder and owner of Williams Law Group, and you are here tonight with me and our special guest, Christine Matus, who is a special needs attorney from South Jersey. Her office is down in Toms River. She also has an office in Red Bank, and she's been talking to us about how do we protect and advocate for unique families and giving them unique solutions. So thank you, Christine, for the valuable information you've given me so far. And I want to circle back now to Steffi, who has another question about SSI. And her question is, can SSI be retroactive? Her son was denied based on child support. He's now 19 years of age.
Yes, it can, but I would love to, it's a case by case situation as to the reasons why he was denied and as to when you applied. But typically, I've seen that where there is a retroactive award that would be provided. And two things we need to be aware of is that, I always say, what the government gives you, they taketh away. So when you are applying and say that you finally get that award, and they tell you, and this happened to a client of ours, that yes, after how many years we were, denied, and we finally received our award for SSI. So not only are you eligible, but we owe you from the first time you applied. Great. It was a number of about 25,000. Okay, wow. Hey, that's money in his name. That's money that could very well throw him off his benefits again. It's a vicious circle. So what do? We may need to look, there's two solutions to this. One is that we may need to look into a certain type of trust that we can place those funds in the meantime so that we can make sure they're protected. There are various clauses and drawbacks that we have to be aware of if we create a trust based on retroactive award. Okay. The second, though, is that a lot of times they'll give you a time to spend down that amount, Steffi. And if anyone's been in this situation, they'll give you a time to say, okay, here's your big award that you did deserve. But it needs to be spent down by a certain amount of time, because otherwise then you're deemed disqualified. So you do need to probably reach out to people who could help you and have this nuance so they can discern what you think you can spend down, what you can spend it on. And there's various ways that we can help counsel people to see what's been done and what can be used to for the money. But sometimes, if it doesn't fall in any of those categories, we may have to look to a type of trust, a type of special needs trust to place the funds in them so we can continue eligibility. If the funds, and one thing I need to bring up, Allison, there's various types of special needs trusts. When we create a special needs trust based on funds that are the child's money, it's considered a self settled trust. Another word for it is a first party trust. And in that trust, there is a clause. It's called the payback provision. It means that if that child should die and there's money left in that trust, that money should be paid back to the state, paid back to Medicaid. It's a payback provision. That is one of the issues. There are other types of special needs trust that does not have that payback provision, but it's based upon where's the money coming from. So if you have funds coming from other people that are not the child's money, That is called a third party trust, and that does not have a payback provision. So, for example, for my husband and I, we have a trust for our daughter. In that trust, there is no payback provision. Why? Because right now we take care of our kids, we take care of them, whatever their needs are. The issue is, God forbid, we're no longer around. Our assets, we would like a portion of it to go to our daughter, but not to her directly, right? Because if it goes to her in her name, she will not be eligible for the benefits we want her to have. So instead, we put them in that box. And because it was our money, we don't need that payback provision. So these are the little nuances that are very important to have. And if you don't have them, it can either cost you money that you don't necessarily have to provide to the government, or it could disqualify a whole trust because it wasn't mentioned. A lot of times people will say, "Well, I had a first party trust. I think I did, but there's no payback provision in there." Then that trust may not be effective, may not be valid, and you may have a penalty. So, we really need to look for those things. But yes, Steffi, for the most part, if you're awarded, there will be retroactive funds provided to your son. But again, a case by case basis, but for the most part, yes, look into it. Look out for that letter that gives you the requirements of when you need to spend that down, or seek out people who do help in special needs planning to make sure maybe we do need a trust in place, or maybe not, depending on your circumstances. But great question.
Yeah, definitely. And for those of you that are interested in learning more about this, one of the things I was remiss in not mentioning at the start of the show is that Christine's office does have a resource that she gives out to clients. And even though this is really about something very particular, it deals with estate planning. The very topic of special needs trust is something that I think is something that's timely and really should be explored. So, Christine's office has a book, Basic Estate Planning for Parents of Children with Special Needs, and you can get that resource. We're going to drop the link into our comments, but it's you can email Christine's office at admin@matuslaw.com. So again, that is Basic Estate Planning for Parents of Children with Special Needs. So, Christine, you mentioned special needs trust, and I think that's just it's interesting that it comes up now, and it's interesting that it comes up after I kind of flubbed over a term earlier called the HIMSS trust, which is what we first as family law attorneys kind of, I guess, we have the most exposure to. Which for those people that are not familiar with that, HIMSS stands for HEMS. That's Health, Education, Maintenance, and Support. And that's a very different type of trust than a special needs trust, but there are other types of trust. Can you kind of fill us in on what the different types of trusts are and what their purposes are?
Oh, absolutely. I mean, again, one of the big things that I find valuable is that when we have our peace of mind sessions, when we have clients that come in and we try to figure out what we can do to help them, our main question is, what are their goals? Because there are many different types of trusts. And even in the special needs category, there's a couple of categories, and we need to find out what their goals are. What are the things that they would want to avoid, and what are the things that they really want to achieve with regards to their loved ones? So, even moving away from special needs, Allison, if we have clients that say, Chris, we're really concerned about whether or not we could protect some assets and not have them totally liquidated in case we need long term care. Many of our clients may be looking into the future, and they realize that, if God forbid you need to go into a nursing home or need extensive long term care, it's astronomical. The studies that I've seen, you can get some pretty good minimal adequate care, $10,000 a month at a nursing home, but I've seen them at $15,000 or $16,000 per month. And the average person who lives in a nursing home is about 3 years or so. So you calculate that typically depletes many of the assets that our clients may have. So what's the solution? Some solutions would be looking into a long-term care insurance. You can look into that, and that you would really need to seek out advice of an insurance broker or so to see what are the pros and cons of that. If you don't have that availability, there's also long-term care riders, things that could be attached to a life insurance, much more affordable. But and everything has its limits, and everything has to fit the piece of your life. So we would have to really take a look if that's a good fit. And the last thing would be a type of trust that we could create to protect an asset so that it would not be countable if they needed to have some governmental resource, such as Medicaid, to help them pay for their long term extensive care. Um, Lots of little rules with regards to that, but we have to see if it fits the client. And again, looking at their goals, Allison, if it fits, great. But there are some times where it may not even be a goal that they were thinking of. So then that's our job to reveal and help them see certain things that they may not have considered or realize they're using a tool for. Instead of throwing our hands up in the air and just say, I guess it's just going to have to pay it and that's it. There's other solutions that we could do. In our special needs trust, again, we had dwelled on it, but the main issue is whether or not we're protecting assets that originally belonged to the child or the adult with special needs, or is it funds that are coming from another source? We've helped a lot of also personal injury attorneys in that they may have clients who were injured in a catastrophic type of car accident or any type of accident. And as a result, it looks like they won't have the chance to maintain a typical lifestyle. They may need to qualify for, say, Medicaid and SSI. But with this large settlement, many of them have already some resigned that, well, we'll have to choose one or the other. Either, use the settlement and pay for all my medical, or what can I do? Why can't I have both? I'll just bypass having Medicaid or SSI. Well, we've always tried to educate and help clients that you can have both. You can have both worlds. You could have the protection of the governmental benefits, and you can also make sure that your settlement money is also protected. And how? Through a special needs trust. And again, that's the first party trust, but there's a box, there's a tool that we could use for that. And it's something that we just need to get the word out more and more to clients, Allison, because it is sad when I do meet clients who told me that they had a settlement and they're almost dwindled down with it, and now they're going to qualify for their Medicaid. And I couldn't help but just to find out, well, why do we have to do that? We really could have had both. We could have
Mhm.
had the best of both worlds considering the circumstances.
Yeah, definitely very, very tragic circumstances if people don't consult an attorney that can help them with these sorts of issues. So, Christine, you are just a great resource, and I want to thank you so much for coming on and sharing all this great, valuable information. We do have another couple of questions, and we're coming toward the end of our hour. So, I just want to again thank everyone that has been tuning in. You are watching Moving Families Forward with Williams Law Group. I am Allison Williams, the founder and owner of Williams Law Group. And our guest tonight is Christine Matus, who is a special needs attorney from South Jersey. I do want to ask that for those of you that were here and were getting value out of the wonderful information Christine was sharing, please do share the live. The more people that you can, in your network of contacts, allow to get access to this information, the better we are doing at cultivating a culture of information share as well as assisting people in the community that have these issues. So, again, please do share the live. Comments, questions are always appreciated. And with that, I want to turn to a question by Janice Sheridan. She asks, what disability is considered special needs to qualify? I've never heard that question
Oh,
before,
great
but I think
question.
it's a great one. Yes.
It is a very, very good question. Basically, for special needs, they look at the definition of what the Social Security Administration defines it. And many of the times, without going into detail, a lot of it is looking for a severe incapacity, either intellectually or physically. And there has to be a time in which that person can't carry out activities that a typical person can do, or that they are unfortunately prohibited from carrying out a lifestyle that they could live independently. I know it sounds very vague, but I think there's a purpose to that. I think there's a purpose for them to being that way because now and then we do discover more issues with people that we may not have realized that could prohibit them from carrying on typical situations, activities that we probably didn't expect. And to always be specific with a certain category that only blind people are considered, only deaf people, I think that puts a big majority of the population at a disadvantage because there's many nuances of what it is. So typically what you would need is that you would have a physician, a doctor, or someone in the medical field evaluate that person, and they would give in their medical opinion. Can this person carry out this type of activity, whatever it would be, in a typical to their maximum benefit? And if they can, then they can. If they can't, what are their limitations? Again, words that I really hate using, but what are the things that they can't fully participate in? And is it enough that they are unfortunately considered not enough to be considered independent? But I encourage you to look at, if you look on the website for Social Security Administration, they do give a very, very thorough information about who is considered disabled. If it is a person that falls into those categories, Jazz, then that's a person that we consider special needs. That's a person that then would be considered for us to take a look at our toolbox, and that we could see what we could do to serve them, to provide solutions to them, considering their situation. And, I'm always learning something new. A lot of times I like to look at awareness sites, and always surprised about what month is a certain awareness month, and I'm learning about that because there's many times I learn about certain conditions that I've never heard about, conditions that are exceptional. And what I like is that people are recognizing that and honoring those people. But if you even just look at that, it's eye opening to find out these are people that probably fall into those categories, that are considered special needs, that are considered needing help with the toolbox that we have. So, but great question, Janice. Just a really, really good question.
Yeah, absolutely. So as we are winding down, I do want to note that we have your website in the comments, matuslaw.com. There is always something new to learn, but Christine is somebody that didn't just learn what she needed to help clients in the immediacy, but really adopts a lifestyle of learning in this area because it not only impacts her family, but it also impacts the people that she's been serving, really in, across New Jersey for years. And Sheila Olive was nice enough to note that she's always looking for resources for her special needs son. So Sheila, I don't know how long you have been on the live, but I do want to remind you that you can get a copy of Christine's book. She gives it out to all of her clients, and if you are not a client of the firm, you are still welcome to request a copy. She's holding it up there. Basic Estate Planning for Parents of Children with Special Needs. And you can secure a copy of that book by emailing her firm at admin@matuslaw.com. So Matus Law has been dropped into the links by our wonderful marketing assistant, Liana. So if you see that, you have the spelling of Matus, Matus Law, Matuslaw, and the first part of that email is admin@matuslaw.com. So again, get your free resource, Basic Estate Planning for Parents of Children with Special Needs. It's a great primer on some of the things that you need to be thinking about. And obviously, if you need more in-depth information, Christine Mattis has been just such a wonderful guest on the show. Thank you so much for coming, Christine, and sharing with
Thank you,
us.
Allison. My pleasure. Really, thank you so much. It was just so good to be able to share what we experience and what we know.
Yeah, absolutely. I mean, we've covered a lot tonight. We talked about child support, we talked about life insurance, we talked about qualifications for disability. We had great questions from the guests, so I do want to thank you all for watching. For those of you that have not already done so, please do share the live so more people will have an opportunity to learn about how to protect and advocate for their special needs child or adult, and how to craft unique solutions for unique families. And we've come to the end of our hour. So again, you are watching Moving Families Forward with Williams Law Group. I'm Allison Williams. Our guest tonight, Christine Mattis, has been here and a great joy to have on the show. Thank you all and have a great night.